Good afternoon, everyone, and committee over here on this side. Bravo, this side, not not so much. But it's Tuesday, March 10th. Welcome to House Judiciary. Glad to see everybody. Our first item of business is to approve the committee minutes for February 11, 12, 16, and 25. Do we have a motion on that?
Thank you, Madam Chair. I move that we pass the minutes on February 11th, 12th, 16th, and 25th favorably.
Sorry, do we have a second? Representative Osmond seconds. Any discussion, any additions or corrections to the minutes? Okay, seeing none, I guess you can close. We don't.
I can close.
Okay. All those in favor of approving the minutes, say aye. Aye. Opposed, no. Okay, the minutes are approved for those 4 dates. Thank you for your work on that, Lene. Okay, today we're going to hear 2 bills and then do possible action on up to 4 other ones, but we'll just see what we get through. We'll try to go ahead and get a few of them done today so we have a shorter day tomorrow. But I will go ahead and open the hearing on Senate Bill 463 and ask our advisor to give us a brief.
Madam Chair, good afternoon, committee. Jason Thompson, Office of Revisor of Statutes. Senate Bill 463 was requested in the Committee on Judiciary by Senator Warren on behalf of Veridon Strategies. It passed out of the Senate after amendment in committee and committee of the whole by a vote of 30 to 10. So the bill comes to you, and the bill brief you should have and the bill version you should have is as amended by Senate Committee of the Whole. The bill prohibits certain persons from recovering damages in certain civil actions, and it creates requirements for actions involving negligent security. Subsection A is a part of the new section of law that a person who engaged or participated in wrongful conduct or attempted to engage or participate in wrongful conduct shall not bring an action for negligence or collect damages for negligent conduct related to such wrongful conduct. The party against whom negligence is alleged will have the burden of proving by a preponderance of the evidence that a person was engaging or participating in wrongful conduct or attempting to engage or participate in wrongful conduct. So this is the subsection that prohibits those certain recoveries and certain actions in negligence if the person was engaging in wrongful conduct. So that's the first provision there. Subsection B in the amended bill, so skipping the stricken subsection B that is no longer relevant, really. Subsection B in the amended bill provides that an action for negligent security, which is a defined term in the bill, by the way, an owner or occupier has no duty to protect an invitee or licensee from any type of wrongful conduct of a third person unless the owner or occupier has actual knowledge of previous occurrences of substantially similar wrongful conduct on the premises within the immediately preceding year. And if the owner or occupier has that knowledge, they have a duty to take reasonable care under the circumstances. And then there are a couple of presumptions that they met this duty if they meet one of the three provisions of the bill involving requesting assistance of law enforcement, following guidelines of a reputable party related to security and safety, or hiring a security contractor. There's a little bit more in that section. I think the last thing I'll say about that subsection is that a person who's committing criminal trespass or a person on the premises outside of posted business hours or during a period of time that the premises is not open to the public shall not be able to maintain an action for negligent security. So there's a limitation on the duty at the beginning of that subsection, and then toward the end, there's a limitation on recovery if the person is committing a criminal trespass. Further, that subsection requires an apportionment of fault, and there's a specific provision in there for that. And yeah, a whole lot of provisions actually related to apportionment of fault. And I go into that in a little bit of detail in the bill brief, but I'll not do that now unless you have particular questions about apportioning fault in a negligent security action. Subsection C then gets back to basically an exception to the two provisions I just talked about. Nothing shall prevent a victim of crime from recovering or receiving restitution. Subsection D says that this new section will apply to all claims that are pending or filed on or after July 1, which is the effective date of the bill. Subsection E has your definitions. I mentioned that negligent security is a defined term. That's a kind of claim or action that's specified. And then wrongful conduct is also defined. And I noted that the one of the amendments on the Senate was to change the definition of that term to mean certain violations of federal or state law that we can get into if you have questions about that particularly. And then finally, there is a severability clause in subsection F. As I mentioned, it would take effect on July 1 if adopted, and I will answer questions if you have any.
Okay, thank you, Jason. I'm sorry, I do have one quick, I think it's a quick question. That section where it's basically most of page 2 on the bill, could you you kind of mentioned there's a whole set of things, but you went over it a little bit fast. And it's kind of that first section, first paragraph on your page 2. Could you just give us a quick synopsis of that?
Sure. So Madam Chair, you're talking about the very long subsection B about negligent security actions. So let me start by just defining that so we're clear what we're talking about, since I hit at it a couple of times but didn't say it. Those are claims against an owner or occupier or security contractor that sound in tort or nuisance arising from an alleged failure to make or keep the premises and approaches safe and seeks to recover any damages. So the negligence is related to not keeping the area or the approach to the area safe for these licensees or invitees that are coming into or on the property. So the subsection B1 is talking about how there's no duty to protect an invitee or licensee from wrongful conduct of a third person unless the owner has actual knowledge of previous occurrences of substantially similar wrongful conduct on the premises within the immediately preceding year. So it narrows the common law to that specific rule at the bottom of page 1 and on the top of page 2. And then it provides that they meet that duty if they meet one of the 3 items near the top of page 2. That would be requesting law enforcement assistance and following instructions, following guidelines of a third party, or hiring a security contractor. So those would all meet that duty that is now statutory. And then B2, which is on page 2, talks about how the owner or occupier has no duty to protect someone, invitee or licensee, from the third person if that person is on the premises for the purpose of or in the course of engaging in wrongful conduct. So it also exempts them from a duty in that circumstance. And then B3, a little further down on page 2, talks about if a person is committing criminal trespass, that's the reference to KSA 21-5808, or they're on the premises outside of posted business hours or during a time it's not open to the public, you're not allowed to maintain an action for negligent security if you've done either of those things. And then B4, if they've engaged a security contractor, the contractor has the same duty as the owner or the occupier. And then B5 is where you get into the liability for negligent security and the apportionment of fault. And there's a whole list of things under there about how you apportion the fault, assign the damages to which party, et cetera. So hopefully that gave you a little bit more than my brief discussion.
Hey, committee, what other questions would you have for our reviser, Representative Carmichael?
Thank you, Madam Chair. Mr. Thompson, directing your attention in particular to page 4 at the top, the language that was added, or perhaps better described as modified by the Senate. Let's say we have a situation where an 8 or a 10-year-old child is attracted to a sand pit that has no fences. there are a number of cases in Kansas which deal with children wandering into sand pits with no fences. That child, though, presumably would be trespassing, which is I believe, a Class B as in boy misdemeanor. If that be the case, it would appear that the sand pit owners are now off the hook, because when children wander into the sand pit that's been negligently secured, they're committing a misdemeanor and hence can have no recovery. Do I interpret that correctly?
So, Madam Chair, I'm going to take a two-part approach
Sure.
to that question. So negligent security-wise, if they're committing a violation of trespass, they are specifically excluded from negligent security action under B3. That's the provision I was talking about a minute ago, page 2, line 16. So, and I don't know that it makes a difference whether it's a child or an adult. I mean, it might in common law, but I don't know that it does in the statute. So,
And I don't contend that it does under the statute. I just picked that example.
as to section 1, I get a little hesitant when I'm doing hypotheticals, but I mean, I can see that if there is wrongful conduct, you're not allowed to bring an action for negligence related to the wrongful conduct, and the burden would be on the owner or the person who, you're suing to show that that person engaged in wrongful conduct, and they're not allowed to recover. So, pretty good case based on your facts, but the lawyers behind me might be able to argue that a little bit more vociferously than I can, trying to maintain neutrality.
I understand. I appreciate your assistance. Thank you, Madam Chair.
Any other questions for the revisor? Representative Lewis.
Thank you, Madam Chair. And Jason, I'm going to ask you about page 2 and the apportionment of fault that you went over. Is that any difference than just comparative negligence, which is applicable, I believe, in Kansas?
Madam Chair, comparative negligence is applicable in Kansas, so you're correct as to that point. I did not do a straight comparison, so hopefully the conferees can tell you how it's different. I know, for example, that there might be some. There are a couple of pieces that I don't think are common law that involve the evidence or arguments there in lines kind of 34 through 41. I suspect that some of those may not quite be current common law, but I can't say for sure. And then the rule about the total percentage of fault who engaged in wrongful conduct being less than the total percentage apportioned to all other persons. That strikes me a little bit as what common law is, current Kansas law is on comparative contributory negligence, but it might be a little bit differently stated. So I guess that's my way of saying it. I think it goes a little different than current law, but I can't get into the specifics. Hopefully the conferees can help me out on that one.
Thank you. I mean, because by and large, what this bill does is it tries to more specifically define contributory and comparative negligence in a specific context. So, that's, I mean, it would be important to know how it's changing what we all otherwise would have in the law. That's just a comment.
Okay, thank you. Other questions for the revisor? Okay, thank you, Jason. Appreciate that. Somehow I think we may have more questions as this goes on, possibly. Okay, we'll call the first proponent, James Carlson from Stillwater Technical Solutions. Managing partner. Welcome to our committee. Thank you for being here. I don't think we've seen you before. Is this your first time here? Yep, got the light on.
This is my first appearance in the House Judiciary Committee, and I haven't appeared before the legislature for about 10 years.
I will tell you, Madam Chair, if I might, he's from Garden City, so he must be a
Okay,
good
nice. He's
conferee.
got to be a nice guy then, right?
That's a great way to start this testimony. Thank you. Good afternoon, Madam Chair and members of the House Judiciary Committee. Thank you for your service to Kansas and your respective districts. So we do appreciate your efforts in being away from home and your contribution to the lawmaking process. My name is James Carlson, and I'm appearing today in the capacity of the managing partner of Stillwater Technical Solutions, and also as a landholder in Finney County, Kansas. So I have two positive ways to contribute to the general fund, not just one. And so Stillwater is a Kansas-based policy, research, and advocacy firm. It was established in 2011, and Stillwater educates and equips local and state elected officials for engagement with federal agencies during administrative processes and administrative rulemakings and policy actions at the state and local level. So that's what Stillwater does. I'm supporting SB 463 from the perspectives of both, as I said, but SB 463 appropriately makes it more difficult for those engaged in criminal activity to sue an established business or private property owner for injuries that arise during illegal activities. For example, if a burglar is injured by shards of glass resulting from a home intrusion, they cannot later claim negligence against the homeowner for not alerting them as to the danger of sliding glass doors. As I reflected on SB 463, I wonder what former Kansas lawmakers would have thought or would think if they were faced with the need to protect vulnerable citizens from uninvited intruders who are injured during invasive acts on private property. This is where we find ourselves with respect to personal responsibility in this particular culture. SB 463 also affords common sense statutory protection to home and business invitees that may be injured from third-party criminal conduct, provided that the owners had no knowledge of a risk and took reasonable precautions. And I think the attorney from the revisor's office told us about that. But what I really like about this bill is that 463 is it would be good and necessary and timely addition to the Kansas statutes is that the bill specifically calls out what the minimum presumptive obligations are that constitute an exercise of reasonable care by the owner or occupier. They're broad, but they're substantive standards. So they're sideboards to the statutes as I see it. And I'm not an attorney, so just if you're going to ask, I'm not an attorney. I do practice administrative law, but I have attorneys that do all the interpreting and all that crunching for me. But as a seasoned policy professional, I would like to draw this committee's attention to a deeper problem where activists and trial lawyers are using sue and settle and precedent litigation as a pathway to achieve policy goals. This is happening across the nation. SB 463 addresses the problem of courts making law by providing legislative side rails, policy checks, and statutory balance. For these reasons, I respectfully urge the House Judiciary Committee to consider adopting this useful and protective legislation. And with that, Madam Chair, I'll stand for questions from the committee.
Okay, thank you. I think we'll go ahead and hear from the other proponent and then ask questions of both of you at the end, if that's okay with you.
Yes.
Okay, thank you. That's great. Okay, we'll now have Bo Royston from Fusion Law Alliance for Consumer Action Fund. Welcome back to our committee.
Thank you, Madam Chair and members of the committee. It's great to be back on
you.
a beautiful day today. This is a Senate Bill 463 is an important bill at the intersection of two different areas of law, criminal law and tort law. And the key issue underlying this bill is that criminal activity should not be a basis, a profit center for tort claims. And that's the unfortunate scenario that we see play out, not just in Kansas, but obviously in many states. And this ends up being a very important consumer protection issue because homeowners and businesses are having to pay more in insurance when they have to insure themselves against liability for people who themselves are wrongdoers. They've committed criminal conduct or where criminals have created collateral damage for third parties that also creates potential tort liability. So what this bill does is it's a very common sense approach to this issue of wrongdoers trying to get a payday or plaintiff's attorneys trying to get a payday and profit off the actions of wrongdoers. It's very straightforward. It simply says that someone who participated in wrongful conduct or attempted to participate in wrongful conduct cannot bring a negligence claim related to their wrongful conduct. That's subsection A. And then subsection B deals with the specific tort of negligent security, and it sets forth very clear and practical rules for businesses to follow. And it says if you're a business where this type of wrongful conduct has been happening on your property, it's happened more than once in the past year, then you can be held liable. But it also tells you what you should do, and it's three common sense things. Talk to the police and follow the instructions of the police, follow the instructions of a reputable third party on security, or hire a security contractor. So if I'm a business and I have this type of problem occurring on one of my properties, I can do one of those three things. If I'm a business where some sort of unexpected, unforeseeable thing happens on the property, what this law says is it says I'm not responsible for that criminal conduct. And there's some examples from Kansas law, which I'm happy to get into more in the questions, but for example, you have a apartment complex where there's literally a gang shootout, and the apartment complex had no connection to this gang in terms of the person being a lessor, a tenant, et cetera. But that apartment complex had to go through 6 years of litigation and an appeal to ultimately get out of liability. So they were dragged into litigation for 6 years because they were simply themselves the victim of gang crime. Or in another case, this case is next door in Missouri, but it involves a Kansan, a restaurant where a drunk person literally was pulling down a fence on himself, trying to climb in and essentially trespass onto the restaurant's property, suffered injuries, and was able to get a $1 million verdict against the restaurant. These are the kind of, a third case, which is also Missouri, but my understanding is right next door, is a woman who was shoplifting and was kind of taken back of the store, got into a physical altercation with the store personnel and sued the store for negligence for her own shoplifting. These are the kind of common sense things that I think citizens and anyone with common sense says this is not a proper tort lawsuit. And what this law does is it very narrowly protects against that type of litigation abuse. With my remaining time, I want to just quickly talk about what this bill does not do, because I think that's super important for understanding. It does not dramatically rewrite Kansas law. It leaves the Kansas comparative negligence regime generally untouched, and I'm happy to answer questions about exactly what the differences are. It does not allow technical violations of state or local criminal law to trigger the limitations. It exempts Class C misdemeanors. It exempts the unclassified misdemeanors. The bill safeguards victims' rights because it reiterates that victims are entitled to criminal restitution, which is a function of criminal law. And it leaves in place the existing duties for negligent security for property owners where they do have notice that their property is at risk of specific type of criminal conduct, but it also gives them a very clear pathway, a practical pathway that a non-lawyer can understand. Talk to the police and follow the police instructions, follow the instructions of a reputable third party, or hire a security contractor. So with that, I welcome questions and hypos. I understand this is a very technical bill, but I think it's an important and common sense bill, and I appreciate your time, Madam Chair.
Okay, thank you so much. We'll go ahead and have questions now for the two in-person proponents. Committee, who has questions? Representative Osmond. And you can say if it's for one or the other.
Okay, thank you very much, Madam Chair. I guess this question is for Mr. Roysden, sorry. You listed off a number of examples, and I'm sorry that I missed the locations of some of them. You said one was in Missouri. Were any of your examples from the state of Kansas?
Yes, absolutely. So the first one I gave was from Kansas, and that's the one where the apartment complex had the gang shooting, and somebody who was injured in that shooting sued. My understanding is they were a participant and they were involved in it. This is a Kansas Court of Appeals case from 2022. That case took, my understanding is that took 6 years to litigate for the apartment complex to ultimately not be liable, but they had to pay for attorneys. I do have some other Kansas cases as well. That case was called Estate of Debralon Bell v. 617 West LLC. The next case I have is Blalock v. SRKBS Hotel. That's a District of Kansas Federal Court 2024. This was a woman was hit by a stray bullet from a shootout. Again, she filed a lawsuit against the hotel. The hotel had no connection to this. This was random violence, but yet, obviously, if a hotel has to pay for that, it's gonna harm consumers. A third case, Kansas 2013, is the Wrinkle v. Norman case. That's where a neighbor trespassed and suffered injuries to his back and sued for damages. Ultimately, the Kansas Supreme Court concluded he wasn't a trespasser, but that shows kind of this bill, obviously, for trespassers would prevent that type of thing. The other two cases I had are from Missouri, just because I think the facts are very helpful. And I think these cases exist in Kansas as well. It's the percentage of cases that end up in a published opinion is very small. So one was the guy who was trying to climb over the fence and hurt himself. The other was the shoplifter who got in the altercation. Those cases are from Missouri.
Okay,
But
thank
three of
you.
them are Kansas.
Just as a quick follow-up, I mean, we both understand anyone can sue over anything. And so the question becomes, if this bill were to become law, how would that have retroactively affected any of these cases? Or would it affect future cases? I mean, given that you can sue for anything and then the court needs to sort it out. So,
That's
yeah.
a great question. So in terms of the bill's effect, it affects, on its effective date, January 1st of this year, it affects to any future cases or any pending cases. Why this matters, because you're right, the courts can sort it out. It simply gives defendants a very concrete and practical way for an early resolution of the case. For example, if the plaintiff pleads guilty to a Class A or B misdemeanor, the defendant can put that in front of the court in a motion to dismiss and say, court, please take judicial notice of this. This person has already been found to be a wrongdoer. This tort lawsuit needs to end. Or they can bring an early summary judgment. So it allows a vehicle for the litigation to end much sooner, less cost, and thereby protecting consumers, shop owners, homeowners, et cetera, from the litigation dragging on for years. And that's kind of the idea behind it.
Okay, other questions? Representative Carmichael.
Thank you, Madam Chair. Since you're there, Mr. Royston, you were speaking very quickly, and we're going to have to look up these cases. In fact, we're not going to. My friends over at Legislative Research are going to look these cases up. One of them was a 2022 case from the Court of Appeals, the state of, and then give me the last.
Yeah, absolutely. And I'm happy to get you guys this in writing as well. But the case is Estate of Debralon, Debrylon Bell, Bell, v. 617 West LLC. And I apologize for speaking quickly.
B would mean District of Kansas, but I thought you said this was a Court of Appeals case.
That case is Kansas Court of Appeals. The second case, which is Blalock, Blalock v. SRKBS Hotel LLC. That case is the District of Kansas 2020.
And then we had Winkler versus Norman as well.
Correct. That's in Kansas.
Winkler versus Norman, as you explained, the holding, though, court determined this person wasn't a trespasser, and so it was apparently decided on other grounds, it sounds like.
That's correct.
Okay. Now let's address this more substantively. In both of the Kansas cases that you rely upon, the court actually found in favor of the landowner and established precedent which shows that Kansas doesn't do what you claim they do in protecting, for example, porch pirates, burglars, etc. Can you give me a single Kansas case where a porch pirate has been successful in suing a homeowner, or where a burglar has been successful in suing a homeowner or a Kansas business?
I can't give you anything beyond those three.
None.
Because they haven't resulted in published opinions.
Or they haven't happened. Explain to me the second thing, though. How in the world was this greedy plaintiff's trial lawyer be able to make a living by losing cases? Explain to me how that works.
That's a great, actually,
Because I practiced 42 years and I want to know how I could have made a lot more money by losing cases than winning.
well, because as you know, 90% of cases settle. And so you can make money by filing cases and settling them for nuisance value. And that's where the role of the legislature to define the tort duty is paramount. And so by making clear that there's no duty in the first place, then the rational lawyer is not going to bring that case because they know they're going to lose and they're going to lose quickly.
I didn't bring those cases for 44 years. Thank you, Madam Chair.
Sir.
Okay, committee, who has other questions? Representative Sappington.
Thank you, Madam Chair. So I just wanted to ask you, you addressed some of these, I guess maybe a carve out or an exemption that would exist if there's been a repeat pattern of behavior. So I guess, could you just explain why at that point the property owner would be presumed or have that obligation to then, hire a security contractor, that kind of thing? I just would like an understanding of that.
Great question. So yeah, in the situation where the property owner has had this type of issue happen before, so there's like criminal activity happening in the parking lot and it's a repeating thing, not a one-off thing, then they have the traditional duty that already exists under Kansas law to exercise reasonable care. The statute gives them 3 different ways to meet that duty. One is to hire a security contractor, but that's certainly not a requirement. 2, which I think is probably the most likely one, is to simply report it to the police and then follow any instructions that the police give them. And then the third, which I think is really in the situation where the police don't give instructions, would be to go research, find a reputable security, source and follow whatever they say. If that says, put in more lighting, put up a fence, et cetera. So it's really 3 ways, but it's very practical. And I think the other witness who has more hands on the ground experience can speak to that. But I think it gives property owners very clear steps to comply with any of those 3.
Thank you.
Representative Lewis.
Thank you, Madam Chair. Yes, in your testimony, you said that you'd be happy to explain to us how this law changes comparative and contributory negligence law in Kansas. So if you could do that, I'd appreciate it.
Yes, absolutely. So my understanding of current Kansas law is that Kansas has a modified comparative negligence regime. So the old common law rule was if you were even 1% at fault, you couldn't recover. That got relaxed in most states, including Kansas, to what's called comparative fault, which is at the end of the case, after the jury finds liability, they basically apportion percentages to the different parties. Kansas has modified that comparative fault, as I understand it, to say if the plaintiff is 51% at fault, then they get 0. So it's kind of similar to the contributory, but it makes it more than 1%. What this does is this is specific to negligent security, and it's not intended to override that background 51% principle. Instead, what it's intended to do is it tells the lawyers, when they put together the verdict form, the jury needs to look at the following people. The party bringing the negligent security action, the owner or occupier, any government agency, or any third person whose wrongful conduct contributed, or any other person. So basically first says, make sure when you're doing the comparative fault in this context, you look at all these individuals. Then the second thing it does is it says you can't kind of pollute the jury by appealing to the sympathy of them and saying, well, this guy's gonna go to jail anyway, judge, jury, et cetera. It basically just sets forth some evidentiary rules about what you cannot tell the jury to pollute their comparative fault calculation. And then the third thing it does, which is it simply sets a presumption. And this is when you add up, you have all those people who could be at fault. You add up the percentages. If the percentages of the people who engaged in wrongful conduct, so let me use the gang hypothetical, if all the people who are gang members and shooting, if their fault is less than 51%, then that's presumptively an invalid verdict, unless the trial court explains why it was okay to allocate less than 50% of the fault to the wrongdoers. The trial court can do that, but then that's reviewed by the appellate court. So it basically just says, look, we need to make sure we're considering all the potential wrongdoers. The jury needs to allocate the fault, and if for some reason they allocate less than 50% of the fault to wrongdoers, then the judge needs to explain why that's reasonable. And obviously there's crazy hypotheticals where that could be the case, but most of the time, 50% of the fault or more should be going to people who are committing crimes and that resulted in the tort. So that's the 3 pieces of that.
Okay, other questions? Representative Martinez.
Thank you, Madam Chair. Would this apply? I don't know if this would apply or not, but how would this apply to an outdoor event where they rent a space that the city of Wichita are the owners, and there's, like, I have a big event in Wichita, that's why I'm asking. And there was a section that was being under construction, and it was blocked off with caution tape and some barriers and things, barricades, things like that. So we were worried that somebody was going to go across those barriers and tape and hurt themselves. If that was the case, how does this apply? Does this law apply to that? Who would be responsible? Would it be the ones who rented the venue or the property owners?
That's a great question. So the plaintiff, if somebody were injured, they could sue the people leasing it, and they could sue the city. And I think the law would apply to each part. So for the people leasing it, they would have no additional duty, no duty, unless they were aware of this type of thing happening once or more in the previous year. So if you're just somebody renting it, it's very unlikely you're going to have knowledge of that. So you're, as the leasor of that, you're probably not going to have any sort of tort duty, and you would be dismissed. As far as the city goes, if they had knowledge because they have this dangerous construction zone and there's repeated instances, then they have to follow those three steps. They either have to talk to the police and follow whatever instructions the police give. They would have to, look to some reputable third party or hire a security guard. Those would be the three options for the city. The city could do any of those. So that's how I think the law would apply to that hypo.
Okay, thank you.
Okay, other questions, committee? Okay, seeing none, thank you, appreciate it.
Thank you.
Committee, we have proponent written-only testimony from 4 different folks. A lot of familiar names, so make sure you take a look at that. Eric Stafford, Randy Stuckey, Dan Murray, and Robert Thompson. And then now we will call up the opponent testimony, Jeffrey Wilson, from Dickerson Oxton, and on behalf of the Kansas Trial Lawyers. And tell us where you're from, just out of curiosity.
Wichita, Kansas.
Okay, great. Welcome to our committee.
Thank you, Madam Chair. Thank you, members of the committee. My name is Jeffrey Wilson. I'm here to testify against this bill on behalf of the Kansas Trial Lawyers Association. I wanted to start off, Representative Carmichael, you asked if this bill would eliminate the attractive nuisance doctrine. It would, full stop. Representative Lewis, you asked about how it would compare with Kansas's current scheme when it comes to comparative negligence. So when it comes to negligent security currently, the fault of like an intentional tortfeasor, so a gang member, for instance, who shot up the place because the security was so lax, their fault can't be compared under Kansas law. That's been established in a few Kansas cases. That's in the written testimony I submitted. And the reason for that is that, the business's obligation in this situation where they do have a duty is to prevent this situation from happening. So comparing the fault with someone's actions who they were supposed to take steps to prevent isn't really just, is the way how the Supreme Court has phrased it. I go into more detail on that in my written testimony. I want to talk about some of the things that the proponents have said today. The conferee from Stillwater talked about burglars that could be injured by broken glass when breaking through a sliding glass door. That's never happened in Kansas, nor could it ever happen in Kansas. Business owners, homeowners owe no duty whatsoever to a trespasser in this state. Now, they do have a duty not to willfully injure them or wantonly injure them. But as far as negligence goes, not warning them of broken glass, that would be laughed out of court at the first opportunity by any judge in this state. Mr. Royston said a few things I'd like to talk about. This isn't a profit-generating scheme, as you pointed out, Representative Carmichael. It might surprise you to know the Kansas Supreme Court revised the standard for negligent security in 1993. Since that time, you know how many cases have gone up where the plaintiff prevailed and it was upheld on appeal? 0. It's never happened. Only one case has gone up where the plaintiff actually got a favorable result at trial, and that was overturned. Mr. Royston talked about a few cases, the Bell case he mentioned. So that was a case where the apartment complex, not in the best part of Wichita, had some crime, had some violent crime on the property. But the key thing in that case was the person who did the shooting was specifically trying to track down this person to kill them. He was a witness in a pending case against him. That's how that case happened, and that's why the apartment complex was held not to have a duty in that case. You couldn't foresee someone trying to track down another human being to kill them on purpose. The Missouri cases, I don't know the details of those. We're not here trying to change Missouri law, of course, but it's important to remember that Kansas has a modified comparative fault regime, which means that if the plaintiff is more than 50% at fault, they can't recover no matter what. Missouri doesn't have that. It's pure comparative fault. So even if the plaintiff is 90% at fault and there's 10%, they can still recover 10% of their damages in Missouri. I'm glad that Mr. Royston brought up the Blaylock case. That's my case. It's pending right now on appeal from the 10th Circuit. He obviously doesn't know much about it because he said the hotel in that case had nothing to do with the gang shooting. Let me tell you what happened in that case. My client is a retired lieutenant colonel in the Air Force, returning home from visiting her grandchildren in Colorado. She stops in Wichita overnight, nice part of town, northeast Wichita. And a shooting happens in the parking lot. Bullets come through her room. One of the bullets comes through her room and hits her in both feet while she's sleeping. Now, come to find out, this owner of the hotel had bought it in 2017. And over the 3 years between buying it and 2020 when the shooting happened, the center of crime in the area had literally migrated to be just a circle directly over this hotel. Employees at the hotel were finding ammunition and guns in the rooms, including assault rifles. There was known drug dealing happening on the property. There was testimony in the case that gang members were actually using the hotel as a base of operations because they didn't want to sell drugs out of their own home. They would rather sell it out of a hotel not to attract attention. And while this is happening, every employee we talk to at this hotel is begging management to hire security. Not do much, just hire an off-duty police officer for the night shift, please. It's dangerous out here. Guests are leaving reviews on hotel sites saying, there are gang members outside. I don't feel safe staying here with my family. And they ignored it. In fact, they lowered the rates even further because they wanted to boost up revenue because the manager of the hotel got a nice bonus if that happened. And then predictably, when gang members are literally living and using your hotel as their residence and selling drugs and committing all sorts of crime on the property that you're ignoring, eventually a shooting's gonna happen. What this bill does as amended is it tries to immunize someone who, to give you an analogy, soaks a room in gasoline knowing that people with lit matches are gonna be walking through it. Sure, they may not be the ones lighting the match, but there shouldn't be a blanket rule making them not liable. Lastly, Wrinkle versus Norman, the plaintiff actually was a trespasser in that case, but he had a privilege to trespass. See, in Kansas, if I see my neighbor's house on fire, or I see something dangerous happening, someone's gonna get really hurt if I don't go over there right now, I have a privilege to go over there and try to stop that, to prevent severe harm to life or property. In the Wrinkle versus Norman case, the neighbors saw that cows were out. They were outside the fence, and they were getting onto a highway. And someone was gonna be killed if they hit one of those cows. So he goes over and tries to round him up, trying to be a good neighbor. And he did get hurt. He broke his back on the property, and it was alleged negligence against the landowner. Now, what the district court said was he was a trespasser, can't recover. The Supreme Court said, no, that blanket rule doesn't apply. He has the privilege to go on there. The Supreme Court didn't say that he has to be able to recover. It's up to the jury to figure out if he was at fault for his own injuries, for instance. But this bill would completely prohibit that. You're trying to be a good neighbor. You're trying to save your neighbor from their burning house, get them out of it. Well, if something bad happens, it doesn't matter what the facts are. You can't recover no matter what. And with that, I will yield the remaining part of my time. I have offered a substitute bill attached to my testimony that accomplishes the goals expressed. We don't want porch pirates to be able to recover. We don't want burglars to be able to recover either. Everyone agrees there. My substitute accomplishes that without dramatically rewriting Kansas law. But the current version of the bill does way more than that. And it substantially changes negligent security law and the rest of Kansas law on this topic. Thank you.
Okay, would you stand for questions? Okay. Committee, what questions do you have for the opponent? Should I call on you or not? With that good look on your face, Representative Carmichael.
Thank you, Madam Chair. Counselor, I wouldn't want you to make the long drive from Wichita without having an opportunity to answer a few questions from the committee. At page 5 of your testimony, you discussed what you describe as doctrinal impossibilities and procedural chaos that would arise from this bill. It's at the end of your testimony. I haven't gotten to all of it to read it all. Can you give us what you're talking about here? What are the doctrinal impossibilities and procedural chaos that this bill, in your judgment, would result in?
Well, at the back of my mind, when I read this bill, was the case I have. It's currently pending on appeal. So in that case, assuming this bill could apply retroactively to pending litigation, the jury would have to compare the fault of the gang shooters with the fault of the hotel and anyone else that bore some fault. Here's the problem. Intentional actions are not fault. They cannot be fault under Kansas law. Fault is a very specific term of art. It means negligence that causes injury. If you intentionally hurt someone, there's no requirement to find causation there. It's not classified as fault. It's an intentional act. So it's kind of one of those things. I would hate to be a judge trying to figure out what this means, because you're saying that they have to compare fault. Well, that's not fault that you're asking to be compared in the first place. But beyond that, what it effectively does is it immunizes everybody from these claims. You know, no one's here saying that we have to open floodgates and let all sorts of claims through, but 0 cases have prevailed in 33 years. 0. The law is hard enough. The law protects businesses a lot right now. The way it's written right now, there's no cause of action at all, even if there is on paper. Beyond that, Representative Carmichael, you know, it talks about the attorneys or the parties can't mention the effect that the jury's decision on fault will have on the recovery, which is kind of toothless, because the judge is going to do that very same thing just before the attorneys argue the case. The judge has to instruct the jury that if you find the defendants 60% at fault and the plaintiff recovers 60% of their damages, that's in the pattern instructions the judge is required to read right now. Beyond that, some of these safe harbors, it's not really defined what they mean, like calling the police and following their instructions. Well, does that mean as the event's happening? Does it mean 6 months before? I mean, and the bill requires actual knowledge. So doesn't this bill just encourage willful ignorance of what's going on in your property? I think I've addressed most of what I talked about in that section, Representative, but is there anything else in particular?
You did. And in fact, we heard testimony last week about an apartment complex in Wichita where the same sorts of things are going on, and the city wants to close it down, and some people want a law that might prevent that. But my question for today relates to the intentional conduct. I would assume that almost in every case where law enforcement has failed to prevent a crime from happening on some premises, whether it be Taco Bell in famous Kansas case, or Bruniger, or a number of other cases, Bruniger doesn't apply, excuse me. You would always like to, as a defendant, say, well, is it the police department's fault? They didn't enforce the law. They should have had more officers. But I see in your testimony that you make reference to the bill forcing juries to apportion fault to any government agency that failed to maintain law and order. Can you discuss that concept with us, particularly in a comparative fault situation where you can't compare fault of the person who done the shooting? Can you rightfully compare the fault to the police who didn't prevent it?
Well, it's unclear what that means in the bill, is the first thing I'd say. But under the Kansas Tort Claims Act, the police would be immune from prosecution anyways for that. They would be immune from suit. You couldn't actually bring them in as a party and say they should be liable too. The current law would prevent that. So it would be what we call in the lawyer profession an empty chair. So you have the hotel sitting in one chair, the plaintiff sitting in another chair, and over here is an empty chair for the Wichita Police Department. Well, the jury feels much better assigning fault to that empty chair, because it's not personal. There's no one they can assign it to. They know there's not going to be a judgment against this empty chair over here, for instance. And the standard itself, it's not a recognized common law cause of action, a failure to maintain law and order. I mean, what does that mean? You know, for instance, in my case, we deposed the police department extensively, and what they said was, yeah, we had a lot of calls from this particular hotel. We kept going over there and responding. We talked to the management and said, you know, we offer these free classes, you know, do you want to come to them? And they didn't. I mean, is that enough to comply, or do they have to, you know, spend a significant amount of their budget posting half the force over at this one particular hotel in Wichita? There's no real defined standards for it. And beyond that, it's kind of an illusory thing for a plaintiff. I mean, again, we're assuming here in this case that there is a hotel or a business that was negligent. We've gotten to trial. We've survived summary judgment. The hotel was negligent. It failed to do what it was supposed to do. And now it just gets to shuffle off all of its fault to people with no real standards or guidance on how to do that, and to people that can't be liable in the first place.
Representative Lewis.
Thank you, Madam Chair. So I want to talk a little bit more about this case, your case, the 10th Circuit case. So did you prevail below?
No.
Okay. All right. And can you explain just briefly what the reason you didn't?
Well, we were in front of Judge Crabtree, who's a very good judge in our federal courts here in Kansas, and he issued a lengthy 45-page, I think it was, memorandum order and opinion. And what his opinion decision basically came down to was we didn't have enough evidence of prior violent crime or prior shootings to justify imposition of a duty, to make it foreseeable that something like this could happen. Now, we've appealed that, and our argument on appeals essentially, Kansas law doesn't require it to be foreseeable that this particular thing is going to happen. Being foreseeable that something bad above and beyond the ordinary could happen to your guest is enough. And I take issue with his finding that there wasn't violent crime presented. We believe that there was, for instance. But that was the basis for Judge Crabtree's order.
If I might,
Mm-hmm.
was that on at what stage in the litigation did he issue that ruling? After jury trial, before summary judgment?
That was at summary judgment. So there was actually cross motions. We had actually moved for summary judgment on the issue of duty as well. We thought the evidence was that strong.
And then, so I'm now focusing on if I might, just a few more.
We're good.
Page 1, I guess this would be near the bottom. So I'm going to read it, and then I'm going to, are you saying that under the bill's language, your case couldn't be brought? And I'll accept your position that under current law, it could be, which is your position on appeal. It says, except as provided in paragraph 2, in an action for negligent security, which is essentially what your case was, an owner or occupier has no duty to protect an invitee or licensee, which is what your client was. She was sleeping in her.
There used to be a distinction in the law between invitees and licensees, depending on if they're entering just for free as a social guest or if they're a paying customer. There's no longer that distinction, so we just kind of group them together.
Effectively, that's what she was. Yeah.
Yes.
So no duty to protect your client from any type of wrongful conduct of a third person unless the owner and the third person in your case are the gang types that shot.
Sure.
And yeah. Unless the owner or occupier has actual knowledge of previous occurrences of substantially similar wrongful conduct on the premises within the immediately preceding year. So are you saying that this too narrowly defines previous knowledge as to which would ground your duty?
Yeah, so it requires actual knowledge versus there's situations where someone may say, I didn't know, but you should have. That's one point. The other point is substantially similar within the last year. So in '93, the Kansas Supreme Court did away with what's called the prior similar incidents test, which is basically what that talks about. Substantially similar incidents before the incident you're here suing about. But this goes even further to say not only do you need prior similar incidents, which was almost impossible to find, but they also have to happen within the past year.
Just one more. You're saying that the Supreme Court of Kansas did away with the prior incident requirement?
Yes. So Kansas and I think almost every other state did back in the 80s, I think, and then it really gained steam in the early 90s.
So it broadened the scope of liability, essentially.
Right.
Yeah.
And even then, no case has prevailed since that time that I'm aware of.
Thank you.
Okay, along those lines, I really had the very similar question. So if I could just sort of on that same line, that it seems like this bill would actually be helpful to you because there's a presumption that the duty was met if the owner did those three things, which apparently the owner of the hotel did not do those three things. So their duty wasn't met. And then as far as the wrongful conduct, so apparently you said that there had been like 3 years that the owner had owned that hotel
3.5.
or motel, whatever it was. And had there never been any of that similar? I mean, okay, someone wasn't shot in the foot, probably. That was probably quite different. But there was gang activity, and I'm assuming there was gang activity because the employees were complaining and that kind of thing. So I'm just, I mean, I don't know, maybe this is a question for Mr. Royston, but it seems like this would be helpful to your case. I'm not saying the section about the negligence possibly, but I'm just trying to understand this other section that seems like that would have been helpful to your case. I'll let you say what you think, and then I might see if Mr. Royston has anything to say about it, but.
So I think the reason it's not is that under the bill, there would be no duty in the first place. So in Kansas law, negligence, you have to have a legal duty first, and then we talk about not complying or breaching that duty. Certainly, because they didn't do those three things, it might be helpful because they would have breached any duty they had. But under the bill, because there was no substantially similar incident in the 1 year preceding the shooting, they wouldn't have a duty in the first place.
Okay. I mean, was there ever a gunshot fired?
There was threats to fire guns, but there was never actually a prior shooting itself.
Mm-hmm. Okay, that's fine. I don't know if you would want to mention anything, Mr. Royston, or not, but I'll give you, we have a little bit of time, so I'll let you say if you wanted to address that. And then maybe others have questions, again, for Mr. Wilson after that.
Yes, thank you for the opportunity. So, yeah, I think you just have to look at what it says in terms of substantially similar. That's a defined term on page 3. Occurrences that are sufficiently similar in nature, character, circumstances, and degree of dangerousness to the wrongful conduct giving rise to the claim of negligence and security, such that a reasonable person in the position of the owner would have reason to believe that such wrongful conduct is likely to occur again. Understand that a specific known and physical condition of the premises has created a risk. So to me, obviously I don't know the facts as well as the attorney who's handling the case himself, but if they're finding ammo in the hotel room, if there's heavy gang activity, if it's literally the epicenter of crime in the city of Wichita, to me, this is a pretty common sense standard for the hotel. And then it tells the hotel, okay, you have a duty, but now what do you go do? Most hotel operators, they're not lawyers, they're business people, they're practical people. It says do one of three things. Talk to the police and follow their instructions, go research reputable security practices or hire a security guard. I mean, to me, the facts as described make this bill very common sense. So I don't see what the problem is. In terms of there being 0 cases that have gotten to a published opinion, I go back to that estate of Deborah Lynn Bell, where it took 6 years of litigation. And this is simply another tool in the toolbox for a business that's sued. For businesses that are open to the public, it's sometimes going to be easier to show that a person was engaging in wrongful conduct than to show that they were a trespasser. Because if my store is open to the public and somebody's on the mere fact that they're on the premises doesn't make them a trespasser. But if I have security footage showing that they're shoplifting, or if they plead to shoplifting, that gives me a way to get out of the case early. And so that's kind of the intent behind that. I think this is just really intended to be a common sense bill to say that businesses and homeowners shouldn't have to pay for crime through torts. And I'm happy to answer any other questions, but that's kind of the intent of this.
I think I'll see if anyone has any questions again for Mr. Wilson. Thank you, though, for that explanation. I appreciate that. Any other questions for Mr. Wilson? Representative Barrett and then Carmichael.
Thank you, Madam Chair.
If you don't mind coming back, if you're willing. Okay, thanks.
Thank you for your testimony. I do have a question just under current Kansas law. So again, I'm not an attorney. I know so for criminal trespass, it's not as a law enforcement officer, I can't charge someone who's simply walking on some property unless they went past posted signage saying no trespassing, they went over a fence, something like that, or they've been warned before, you cannot return back to this property. So under those circumstances, let's say someone is criminally trespassing. So there's a field or a wooded area and there's posted signs saying no trespassing, the purple painted trees, and you have someone that trespasses on that property, whether it be a hunter or someone who just wants to walk on the land, but they are criminally trespassing. A lot of rural areas in Kansas, a lot of wooded areas have old wells or there's oil leases that weren't properly filled in by previous owners or previous companies. So under current law, if someone were to fall down, a trip, break an ankle while they're criminally trespassing, could they sue that landowner for not filling in those holes or filling in that well?
I don't believe so, and here's why I say that. And I'm hesitant to say no because it's a great question. It kind of catches me off guard. So, as I mentioned, right now the status of the law, if you're a trespasser, is I owe no duty to a trespasser on my property except to avoid willfully or wantonly injuring them. So, when you're in law school and you get this situation, the hypothetical the professor might give you is someone digs like a Vietnam War style pit on their property with stakes at the bottom and covers with leaves, and a child comes, chases their ball and falls into the pit. That could very well be an example extreme example, where a homeowner might be liable for wantonly, what we call recklessness or conscious disregard for a known imminent risk. So with the oil and gas well, I actually did a ton of oil and gas work early in my career, so I'm kind of familiar with this. I don't think so, because in the vast majority of cases where you talk about abandoned wells, most landowners don't even know they're there. And that's a prerequisite to wantonly or recklessly injuring someone, is you have to know. You have to know it's there, and you have to just recklessly disregard that risk. So like in case of an abandoned water well, for instance, like I think if you just know a well is there, I don't think that's going to create any duty on the landowner. But if you took steps to like conceal it where someone else couldn't tell it was there and they could step on it and then fall down, then it probably becomes a question for the jury to answer. The reality is, even when you do have the rare case where a trespasser does have an ability to maybe go to a jury trial, the jury is still going to assign a substantial amount of fault to that person just for being there and trespassing in the first place. I think the law builds in a lot of protections for landowners, from the front end on a lawsuit all the way to the back end. Kansas juries do not like trespassers, and they're not going to say that you were trespassing, you're not at fault. Even in the very rare case where you can actually get to a trial and survive summary judgment, for instance. Does that answer your question, Representative?
Yeah, I think so. I'll do some research. Thank you, and thank you, Madam Chair.
Representative Carmichael.
Thank you, Madam Chair. Though with your leave, my question is directed to Mr. Royston based on the answer that he gave, if that's permissible.
I think that'll be fine. And then, I think, okay, first let me just say, does anyone have a question for Mr. Wilson? Then we'll be, okay. I think we're good there. All right, for Mr. Royston.
Thank you. I appreciate your leave, Madam Chair. Mr. Royston, you and I are both at a disadvantage. Neither one of us tried the case that Mr. Wilson apparently tried. I'm at a further disadvantage. I haven't read the case, and you apparently have. But keying in on the chair's question, sounds like there's an argument to be made that maybe this would have been a better deal for Mr. Wilson's client if we had this statute in place. I'm not sure I'm ready to agree with that. But Judge Crabtree was appointed by a Democratic president. He's known amongst members of the bar as being a fairly liberal judge. Is he one of these activist, lawfare, wild-eyed judges that we've heard about? Or is this an example of a judge just applying the current Kansas law, which leads to the conclusion there's no need for the bill? Help me.
Yeah, I don't think we're suggesting that federal judge is a left-wing activist at all. What I think is, if the idea of this bill is to give businesses very clear road marks about what their duty is, and how they meet that duty. And so I think, that case happened there, but I think the problem is in the pure common law, there's a lot of ambiguity. There's a lot of things that aren't able to be resolved early. Obviously, in that case, it was. I don't know, I kind of heard two different things from the conferee's testimony. On the one hand, this was like the worst crime area in town. They had ammo in the hotel rooms. On the other hand, it wasn't foreseeable. To me, that doesn't jibe. But either way, what this does is it gives businesses clarity. It gives them, and the goal is not to excuse faulty businesses from liability. The goal is to give businesses clear steps that they can follow. We want businesses to listen to the police and report crime. We want businesses to research what security recommendations are there. We want them to hire security contractors. So I think it is necessary because it makes it very clear in a black and white way that the legislature can do, which courts can't do. Here's how you protect people. We'll stop.
I appreciate you coming all the way from Arizona to tell us that. Thank you.
Always a pleasure. Thank you.
Okay, committee, I think we will go ahead and close the hearing on Senate Bill 463. Thank you for everyone. Thank you to everyone for being here. We'll open the hearing on Senate Bill 426, and we have Donica, I think, giving us a bill brief on that one.
Thank you, Madam Chair. Donica Short, Office of Revisor of Statutes. Senate Bill 426 creates a new section of law and enacts the Kansas Transparency and Consumer Legal Funding Act. Section 1 names the act and provides a severability clause. Section 2 provides definitions of terms used throughout the act. That includes the definition of consumer legal funding, which I want to clarify explicitly does not include expenses directly related to prosecuting the legal claim. The legislature enacted a statute last year related to that. Section 3, subsection A, provides requirements for consumer legal funding contracts. Those include being written in a clear manner using words with common everyday meaning, containing a right of rescission, containing a statement that there are no fees or charges to be paid by the consumer other than what is disclosed, containing a statement of the maximum amount the consumer may be obligated to pay under the contract, clearly and conspicuously detailing how charges are incurred or accrued, and stating that if there is no recovery, the consumer shall owe nothing to the consumer legal funding company. Subsection B requires certain disclosures to be made within the contract. These are material terms and include the funding amount to be paid to the consumer, an itemization of one-time charges, a statement that the consumer legal funding company has no role in deciding whether, when, or how much the legal claim is settled for, a statement that charges shall only be paid from the proceeds of the legal claim, and circumstances under which a person should not sign the contract. The bill further contains requirements for font type and size and locations where such disclosures need to be in the contract. Subsection C requires that a copy of the contract must be delivered by the consumer to their attorney if requested. Subsection D requires a contract to contain a written acknowledgement by the attorney that the attorney reviewed the disclosures, the attorney is being paid on contingency, that proceeds of the legal claim will be dispersed by means of the attorney's trust account or a settlement fund, that the attorney has not and will not receive a referral fee from the company, and will not receive that referral fee. Subsection E provides that if the attorney does not provide the acknowledgement, the consumer legal funding contract is null and void. Subsection F prohibits prepayment penalty or fees. Subsection G provides that a consumer legal funding transaction is not a loan. Subsection H requires the contracted amount to be paid to the consumer legal funding company to be a predetermined amount, not a percentage of the recovery. Subsection I requires within 30 days after receipt of a written request, a consumer shall disclose to any requesting party to a legal claim and each ensure that the consumer has entered into a contract. Subsection K provides that communications between a consumer's attorney and a consumer legal funding company to ascertain the status of a legal claim or a claim's expected value are not discoverable. Section 4, subsection A states that a consumer legal funding company shall not do any of the following. Those include pay or offer to pay commissions, referral fees, or other forms of consideration to any attorney, law firm, or medical provider for referring a consumer to the company, accepting commissions or referral fees from such professionals, advertise false or misleading information regarding services, knowingly providing funding to a consumer who has previously assigned or sold a portion of the consumer's right to proceeds from the legal claim without certain conditions and in writing, have influence over decision-making in the claim, attempt to obtain a waiver of a consumer right, including the right to jury trial, or collude with or knowingly assist an attorney to entice a consumer to bring a claim that the company knows or has reason to know is fabricated or otherwise not brought in good faith. Subsection B prohibits an attorney retained by a consumer or an immediate family member of such attorney from having a financial interest in a consumer legal funding company offering funding to that consumer. Subsection C provides that the consumer's attorney may only disclose confidential or privileged information to the company with the consumer's written consent. Subsection D states that only the consumer is authorized to execute a consumer legal funding agreement unless that consumer lacks legal capacity. Subsection F requires all consumer legal funding companies to register with the Secretary of State. Subsection G provides an enforcement provision, and this was amended by the Senate committee. It states that upon a finding that a consumer legal funding company has willfully violated the provisions of the Act after notice and opportunity for hearing in accordance with the Kansas Administrative Procedure Act, the Attorney General may assess upon such company a civil penalty of not to exceed $10,000 per violation. Further, such company shall not recover the funded amount or any charges. Any civil penalty recovered shall be remitted to the state treasurer. SB 426 would take effect on July 1, 2026 after publication in the statute book, and I can stand for any questions.
Okay, thank you, Donica. Just a quick question. This is not amending any section that we have in law. This is a brand new thing that we're...
Brand new, separate from last year's law.
Okay, all right, thank you. Other questions we have? Representative Vaughn and then Carmichael.
Thank you, Madam Chair. Thank you, Donica. Do you know who this was introduced by and on behalf of who?
Requested for introduction by Mike O'Neill on behalf of the Alliance for Responsible Consumer Legal Funding.
Thank you.
Representative Carmichael.
Thank you, Madam Chair. When I first saw this bill, I thought, what's this thing doing back again? Because I thought it was the same bill we heard last year. So now to demonstrate my ignorance, can you refresh my recollection as to what we did last year in this same general sphere? You mentioned it early on in your briefing.
Sure. That's 6226, KSA 6226, and that is regarding third-party litigation funding agreements. And let me see if I can find the definition exactly. So those are agreements under which any person other than a party, an attorney representing the party, such attorney's firm, or a member of the family has agreed to pay expenses directly related to prosecuting the legal claim. So this is how that's different from the consumer legal funding agreement. So that's prosecuting the claim versus just supporting the consumer if they require support.
I think I understand. Thank you.
Any other questions for Donica? Okay, seeing none, thank you so much. Go ahead, I'll go ahead and call our one in-person proponent, Eric Schuler. Welcome to our committee. Thanks for being here.
Sorry about that. Thank you, Madam Chair and members of the committee. My name is Eric Schuler, and I'm the president for the Alliance for Responsible Consumer Legal Funding. And as the revisor stated, this is kind of a continuation of what happened last year. Last year's bill was dealing with commercial transactions, those transactions that are used to finance the litigation and commercial transactions. This now protects the consumer and consumers within the state of Kansas if they have a legal claim and the funds are used specifically for household needs, mortgage, rent, car payments, things like that, basically keeping a roof over their head and food on the table. And what this the bill really does is ensure that the consumers that are getting involved in these type of transactions are working with responsible companies, that they're doing it responsibly, and they know exactly what it is they're getting themselves into. But also, more importantly, it protects the legal systems. It ensures that funding companies cannot have a say in the settlement or the prosecution of the claim. It ensures that there is no quid pro quo between the funding companies and attorneys and law firms. It makes sure that the legal system is upheld, but also protecting the rights of the consumers at the same time. And finally, there is just one basically typo that was in the definition of consumer that we want to bring the committee's attention to. And it's basically 3 letters that we're just asking for it to be added to it. And under definition, it says consumer means a natural person who resides or domiciled in Kansas. And we just went and add the word is a plaintiff, and then it's supposed to be a state, not just state. So the E was missing on that. And so with that, I'd be happy to answer any questions.
Okay, thank you. Representative Carmichael first.
You were moving quickly. Can you take me back to the page and line and speak slowly so I can make amendments by interlineation, please?
Sure. Under the definition of consumer,
You're at line, okay, I see consumer legal funding. Where is consumer?
consumer, sorry, is on the first page,
First page.
line 35. Consumer
Okay.
means.
Uh-huh.
And then, so we're asking for is, or domiciled in Kansas and is a plaintiff in a civil
At
action.
Line 1, page 2, insert
Right.
is after the word and.
Right, and then consumer includes the estate instead of the state.
That would stand to reason. Thank you. That's all I have.
What'd you say? Okay. Okay, any other questions? Okay, seeing
you.
none.
Appreciate your
Yeah.
time.
Okay, we also have written only proponent testimony from Harrison Hosker, American Legal Finance Association. And no neutrals and no opponents, so we'll close the hearing on Senate Bill 426. And I think we'll go ahead and work just a couple bills. My goal is to get out of here by 5. So I think what we'll start with is Senate Bill 427. Probably should have told you which one I was going to do first. Senate Bill 427. And we'll get Jason to give us a little reminder about that.
Thank you again, Madam Chair. SB 427 is the bill that clarifies the chairperson and vice chairperson of the Senate Committee on Confirmation Oversight will have access to certain tax information and background checks on persons appointed to state offices that are subject to Senate confirmation.
Okay, any questions for Jason about that one? Any amendments on that one? Okay, do we have a motion on that one?
Thank you, Madam Chair. I move that we pass out Senate Bill 427 favorably for passage.
Do we have a second? Representative Sweeley seconds. Okay, any discussion on that bill? You all remember? Representative Bohai.
I know that we don't do conceptual, but do we like the dates and everything on this
We
one?
do. This one is okay. We
Okay.
like the dates on this one. Yep. Mhm. Great question. Thank you. Any other discussion on this one? Okay, would you like to close on your amendment?
Thank you, Madam Chair. I close and move my motion.
Okay, you've heard the motion to pass Senate Bill 427 favorably for passage. All those in favor say aye. Opposed, no. Okay, great. Representative Carmichael would like his yes vote recorded. Okay, thank you. That one we got done. All right, we're going to go ahead and look at Senate Bill 481. And again, ask Jason for a reminder on what that one was about.
Senate Bill 481 establishes procedures in the Kansas Code of Procedure for Municipal Courts related to determination of an accused person's competency to stand trial.
Okay, thank you. Any questions on that one? You remember it was kind of putting municipal courts in an equal spot of the district courts, I think, giving them some flexibility. Okay, no questions on that one? Any amendments? Okay, do we have a motion?
Thank you, Madam Chair. I move that we pass out Senate Bill 481 favorably for passage.
Do we have a second? Representative Sappington seconds. Okay, any discussion on that bill? Oh, I like the date on this one too. Okay, we've got some, I think we've got some plans. Got some plans, so, okay. Okay, seeing no discussion, would you like to close?
Thank you, Madam Chair. I close and move my motion.
Okay, you've heard the motion to pass Senate Bill 481 favorably for passage. All those in favor say aye. Opposed, no. Okay, we have passed Senate Bill 481. The motion passes. All right, we're doing so good. We have time for one more. Oh, yes, you would like your yes vote recorded. Very good. Okay, let's go ahead and do Senate Bill 480. I think we have time for that one. Okay, and I think Jason this time oh no, did you break it? Okay, good.
I'm trying to push the button and I pushed the neck of don't bend the neck of the microphones. Come on, follow the rules. Senate Bill 480 is the bill that revives repealed statutes about estates of absentees that were accidentally on purpose repealed last session.
Okay, they've been revived. Or maybe they'll be revived if we vote yes. Okay, are there any amendments? Representative Carmichael.
Madam Chair, I do have an amendment. If we could have it distributed, I could explain it while it's being distributed if you wish.
That'd be great. Thank you.
The amendment deals with a different section of the probate code than the principal bill. But while we were catching things that needed to be fixed, some practitioners made me aware of a provision that's in KSA 59-1706. And you will find it as attachment A on the balloon amendment. There are perhaps some technical revisions or otherwise that are in the rest of the bill, and I'd leave that to Mr. Thompson to explain if anyone, I don't know, they're purely technical, but at any rate, I'd leave him to explain why they had to make those additional changes. But what the law right now says is if you appoint someone who is not a resident of Kansas as a fiduciary, for example, a trustee of a trust, that you have to find someone who lives in the county, the same county where it's filed, to say, I will accept service of process for the out-of-state fiduciary. And we have to have somebody in state, or best can, so that you can get them easily served. If you need to sue the estate or whatever it is, you don't have to run to Delaware or North Carolina to find the fiduciary. You can sue their designee or serve process on their designee within the state of Kansas. What the law right now says, they have to be in the same county. But in western Kansas, sometimes you don't have even two lawyers in the county, one to file the action and the other one to accept the service. So then you go through a list of guys down at the coffee shop to try to find somebody who will accept service. Some lawyers in Wichita told me, oops, I think I've been designating out-of-county representatives for several years thinking that we'd already got around to fixing it. So, Madam Chair, this is a fix.
Thank you, Representative, and I appreciate you bringing it. So would you like to move? Would you like to make a motion?
Sure, I move the adoption of the balloon amendment before the chair.
Okay, and seconded by Representative Williams. And I just echo, I think this is a great fix. I'm glad that we caught it. It's basically saying the agent can be from anywhere in the state and it doesn't have to just be in the county. So thank you for bringing that. Is there any other discussion on the amendment? Okay, seeing none, would you like to close?
I would, Madam Chair, I appreciate your assistance. I could have gone through a list of everybody that I talked to about this, but the hour is late. So with that, I would close and move my amendment.
Yeah. Thank you. And I'll just add, we asked all the people that were kind of involved with this underlying bill, and they were okay with the addition of the amendment. So saying that, you've heard the motion to amend Senate Bill 480 with the Carmichael amendment. All those in favor say aye. Opposed, no. Okay, we have now amended it. Now we're back on the bill, Senate Bill 480, reviving. Does anyone have any discussion about that? We'll have a motion. Representative Williams.
Thank you, Madam Chair. I move that we pass out Senate Bill 480 as amended favorably for passage.
We have a second. Representative Sappington seconds. Okay, any discussion on this bill? Okay, seeing none, would you like to close?
Thank you, Madam Chair. I close and move my motion.
Okay, committee, you've heard the motion to pass Senate Bill 480 favorably for passage as amended. All those in favor say aye.
Aye.
Opposed, no. Okay, the motion passes, and Representative Carmichael would like his yes vote recorded. Anything else? Okay, thank you, committee. We got 3 things done. I so appreciate that. As we discussed, tomorrow, we will try to work on some of the other bills that we've heard since turnaround. And I suppose if you want an amendment, hopefully you've already talked to Jason, or he will have a very busy night and day. But, okay, anything else for the good of the committee? Okay, with that, we're adjourned. Thank you so much, everyone.